Hi there, Billy Tarasio with Modern Law, and we are doing myth number 3. If you have a history of mental illness, or if the other person has a history of mental illness, mental health diagnosis will prevent you from having custody, or a previous suicide attempt would prevent you from having custody, or being hospitalized for a mental health related condition or addiction would prevent you from having custody. Now, this is a myth because it's not an absolute. I have had clients that had all of these issues, that had previously been in rehab or had previously been hospitalized for mental health related conditions. And this is not a death sentence. This does not mean that you are ineligible from having custody or parenting time with your children. Now, with that being said, people with mental health conditions that are untreated or unmanaged are the most likely group of people that I see that end up having no parenting time or only supervised parenting time. And it's because untreated or unmanaged serious mental health conditions can cause decisions that that will make you lose custody or not follow the guidelines that the court wants you to follow. So, for instance, if you've got a mental health condition, that in and of itself isn't a problem. It really isn't. The question is, how does this condition manifest? So your diagnosis isn't enough to do anything. It's just a diagnosis. Let's say you're diagnosed with narcissistic personality disorder. It doesn't really matter unless someone can show that your behavior is harming the children and that behavior is somehow associated with the personality disorder or the mental health disorder. Let's say that you've been diagnosed with bipolar disorder or ADHD. If you leave your children alone and make really reckless decisions, which is sometimes associated with both bipolar disorder or an ADHD, then you may be looking at losing time with your kiddos because of the reckless decisions you made while, due to your mental illness. If you have been diagnosed with bipolar disorder and it has zero impact on your ability to care for your children, and there are no specific facts that link your bipolar disorder to any sort of problem that you have with your children, you're able to take care of them, you're not abusive, you're not abusing alcohol, then it's really not an issue. Now, what can be challenging is, what about mental health records? Are those protected? What about HIPAA? Does HIPAA protect my mental health records? Not in family court. In family court, all relevant information is discoverable, which means that the other side can request it, and they should request it. If I were the attorney, I would be requesting your mental health records, because if there is an indication that you would be a danger to your child, or if you've been diagnosed with something and you're not current on your treatment, then that could pose a danger to your kiddos. So no, your information is not private, it's not confidential. Now, we can limit the scope of discoverability to that which is relevant. So mental health records are directly relevant to a child custody case, but your previous medical history may not be. And then we could limit the scope of the discovery to what is directly relevant. So that's it for the myth. I know it's a little complicated and a little convoluted, but whatever it is, as long as you take it seriously, as long as you take proper steps, as long as you listen to the advice of your attorney, you're going to be fine and you're not going to lose your children. That's it for today. Have a good one.